Good evening, and welcome to Lawyers on the Line. I'm Paula Polasky, an attorney at the Falsani Balmer, Peterson, Quinn Beyer law firm, and this evening's moderator. Tonight we're talking about workers' compensation. When an employee gets injured on the job, that person has a right to a number of benefits under the law. Handling medical bills and wage loss, changing doctors, getting back to work, and just navigating the system can all be very complicated. Here to answer some of those questions, I'm very pleased to introduce tonight's panelist, Sean Quinn of the Falsani Balmer firm, Kathy Bray, in-house counsel for SFM, and Stephanie Balmer of the Falsani Balmer firm. Please call us with your questions for Sean, Kathy, and Stephanie locally at 218-788-2844, or if that's long distance for you, you can call our toll-free line at 1-877-307-8762. And now for our first question. I'll ask this to you, Sean.
All right.
What types of benefits are available through workers' compensation?
Well, there are three primary benefits. One is wage loss, the other is medical, and the third is rehabilitation, vocational rehabilitation. Now, there are others. The wage loss is broken up into three types. Temporary total, which is when somebody is totally off work, but is not expected to last real long. Temporary partial, that is when they're back to work, but they're working at a lower wage than when they got hurt. And then there's permanent total benefits, which is when somebody's completely off work and they're just unlikely to ever return. The medical is, paying the medical bills. And the vocational rehabilitation can include assistance helping you find work or assistance getting you retrained. Now, there's another kind of large benefit called permanent partial disability, which compensates people for some loss of function. That's not a particularly large benefit, although it is an important one. So those are the big ones.
Okay. Now, Kathy, I noticed that Sean didn't mention anything about pain and suffering, things like that. I'm hurt, I need somebody to mow my lawn. What sort of other things aren't included that people might think
Well, unlike a civil claim where there is things like pain and suffering, loss perhaps of or compensation for a family member to help you with services, workers' compensation is a statutory-based system. And so only things that are prescribed by statute are allowed for compensation, as Sean described, in terms of basic wage loss and some functional impairment, which is on a rating schedule, and then medical bills, along with some supportive help for vocational rehabilitation or back to work assistance. So unfortunately, there's just nothing, no matter how severe the injury is, there is no graduated scale of increased compensation because of the increased pain the employee suffered.
Okay.
The only other thing I'd add is there are also death or survivor's benefits if someone dies as a result of an incident that happened on the job. And that's totally different from the rest of them. And of course, we don't deal with those a lot because it's pretty rare for someone to die on the job, but it happens.
Okay. So getting to the very basics. So I get hurt at work. What do I do? I'll open it up to anybody here.
I'll answer. And it's funny. We were sitting in the room that we all sit in when we were waiting, and the billboard, or not the billboard, the bulletin board here, right here at the TV station, they had the sign here, and it's actually a sign from State Fund Mutual, Kathy's company, who must be the insurer for this company.
And you took down a required notice, but that's okay.
I'm gonna put it back. But it says, if you become hurt, this is what you do. And it says, go to the doctor, tell your boss, and give them all the details. Go to the doctor is obvious. If you're hurt, you should get medical care. The second one, tell a boss, tell your supervisor. That's vitally important. The law says that if you do not tell somebody who is a boss, a supervisor, that you got hurt on the job, then you're not going to get any workers' comp benefits at all. Now, sometimes your boss will know about it right away, but if they don't know and you wait too long, you'll never get a work comp benefit, even though you might have gotten hurt on the job. And too long is generally 30 days. If you wait more than 30 days, you're probably not going to ever get workers' comp benefits.
So along those same lines, Stephanie, so does it matter how the employee tells the employer that they got hurt? Or what does that look like? I go to my employer and I say, I'm hurt?
I would say ideally you do it in some fashion so that you could prove it was done. email, note, something like that. But I think in any sort of employment situation, an oral report would suffice. There's the odd case where an employer denies having had notice, but frequently an employer will have you fill out an accident report of some sort and have some questions for you. Employers have the same interest as employees in preventing these types of things from happening. So it's to the employer's benefit to get as much information as possible to prevent things like this from happening, but also to get the details that they need to provide to their insurer or their claims administrator to help them process the claim.
Great, thank you. Now, Kathy, so on the employer side, say the employee might be at fault for the accident. As an employer, why might I have to pay for an employee's carelessness, for example? So give us the employer's perspective.
Sure. From an employer's perspective, you often get the call. I'm an attorney for the employer and insurer, and you may get a call from your policyholder saying, I don't understand why I have to pay for this. This was the employee's fault. They weren't looking where they were going, or they perhaps didn't use some recommended safety equipment. And generally speaking, it is a no-fault system in Minnesota. So that workers' compensation had a trade-off. The limited benefits that employees receive, as we discussed, they don't get pain and suffering, for example. The limited benefits have a trade-off that even if they are at fault, if they did something they shouldn't have done, they are still getting compensation for an injury that occurred on the job. So that's simply just not taken into account. And similarly, the employer's fault isn't. And so it is a trade-off on both sides. If the employer did something that was negligent, unless it's the most egregious intentional kind, that's the only kind potentially that could come into play, and that's a very rare case.
And just as extremely horrible behavior by the employer could potentially allow the employee to seek pain and suffering type damages in civil law, really, really bad behavior by the employee can cut off benefits, but it's very limited. Like you were drunk on the job, and because you were drunk, that's how you got hurt.
Okay.
Or you were just doing something unbelievably foolish that was completely prohibited. The boss said, never ever do that, and you did it anyway. Those can negate all benefits.
Okay, interesting. We hear this a lot. I got hurt at work, but I didn't go to the doctor right away. Can I still file a claim? If I did tell my employer about it, I just didn't get medical treatment for a while. Stephanie?
Yeah, I'll give a lawyer answer first. It depends. Going back to the notice issue, I was going to pipe in, a lot of people don't report an injury right away because they think it's going to get better. And that usually involves maybe not going to the doctor because they hope it's just a tweak and it turns out to be something more severe. And so I think if you get injured, unless it's really just a scratch, you should go to the doctor and get it checked out. And I think you're going to find that employers and insurers say the same thing. Again, what we're trying to do is keep everybody healthy and get them back to work. And a $150 office visit just to make sure someone's checked out is going to be worth it to everybody. So I think in the course of reporting the injury and having that initial conversation with the employer and or the insurer, claims administrator, everybody should agree that you should just go and get it checked out, just to be safe.
And if I could add to that, I think it's important that you timely get it checked out, because if there is something going on that simply changing how you do your job for a brief period of time would heal the condition, I think it's important that the employee get that checked out, and if they have to work under restrictions for a brief period of time and prevent further injury, they have helped themselves, and it's in the employer and employee's best interest as well.
But, go ahead, Steph.
Well, I was going to say, even if you don't go to the doctor right away, that doesn't mean you're done, okay?
Right,
and like I said, it depends, and it does get very complicated about how much time goes by and what you were doing during that time. If you were going to the doctor regularly, and then after about 10 office visits and 2 rounds of physical therapy, then you report it to your employer and insurer, that's going to be harder than if you wait, say, 2 months and your knee just hasn't stopped hurting and you finally go into the doctor and the doctor says, well, how did this happen? And you say, well, I wrenched it while I was doing XYZ at work. You should report it then. It really varies on the facts. When in doubt, call a lawyer and ask.
And the problem with that scenario you outlined of delay, a lot can happen if you delay seeking treatment or if you delay reporting it. If you have had another incident, perhaps you had an incident at home, perhaps you had a motor vehicle accident, you haven't sought treatment, then you claim the injury actually happened at work initially, and this really just aggravated it, but it's all back to the original. Well, the employer and insurer are going to have problems believing that when this other incident occurred off the job in the meantime, and that's what you started seeking treatment after.
Right. So this question is from Chisholm, and this is something that we deal with a lot. Can you describe what a Gillette claim is? Can you talk about that?
Yeah. In Minnesota, we call them Gillette injuries. Other states might call them repetitive trauma injuries. It's called Gillette because it was the Gillette case in Minnesota in 1960 that developed this line of thought, which
Were you
was.
alive in 1960?
I was not. Thank you for noticing, though.
Getting that out there.
Yeah.
Sorry, proceed.
You're not going to be alive much longer. And that is the idea that sometimes you do something over and over and over again. And you are, a good example would be a person who is a carpet layer and they're banging their knees, with the carpet stretcher every day for hours on end. And nothing ever happened, but after, months or years, my knees hurt. Well, that is a recognized injury too. Now, those are harder to prove. The one I just described would be fairly easy to prove, but Gillette injuries come in all forms, but I did something for a period of weeks, months, years, and now I have back pain or knee pain or shoulder pain, things like that. And they get the same benefits. Everything else about the thing is the same. The only thing that's difficult about Gillette injuries is notice. Because one of the first things I said was, well, you got to tell your boss I got hurt on the job. Well, how do you tell your boss and when? When do you do it? The best time is when you first decide, geez, I better go see a doctor about this. Probably ought to tell your boss too.
Okay. Interesting question. So somebody from Duluth, do work comp laws apply to people who are planting, harvesting, like a migrant worker situation if they live in Minnesota? Anybody have any
There
thoughts on
are
that?
special rules. I don't deal with many entities that are in that kind of work. Southern Minnesota has more of it. Some of the northwestern Minnesota companies do. But certainly there are provisions that cover seasonal workers, migrant workers, farm workers. Then there's a whole different issue with respect to whether they are documented workers or not. So
I know we get this question a lot. Can I get workers' compensation benefits and unemployment benefits at the same time? Steph?
Yes. To qualify for unemployment benefits, you have to be willing and able to work. And when you say able, it doesn't mean that you're able to work 40 hours a week, no restrictions. Unemployment will consider you eligible even if you have some degree of work limitations. For example, you can only lift 15 pounds so often throughout the day, or you only have to sit for so long, things like that. Workers' comp, you would frequently claim unemployment if you were waiting for workers' comp to kick in, or if you had a claim that was filed and it hadn't kicked in, because otherwise I guess the real answer is no, you can't, because they work as an offset against each other. But the complicating thing is that in workers' comp, you can be getting some types of benefits and not others. And so the work comp insurer may be paying for your medical bills but not paying for your wage loss. And in that case, I would say, yes, you can get unemployment. But it does get complicated because arguably you shouldn't be collecting both streams of benefits at the same time in the form of wage loss. So. And if unemployment, like I said, will pay for a while if you're waiting for work comp to get resolved, but then unemployment has to get paid back. So.
yeah, essentially you can't double dip.
Right.
This woman, I'm afraid that I'll be fired if I pursue my work comp claim. Can they do that? Kathy, you want to take that one?
Sure. In Minnesota, there's a statute that prevents or prohibits retaliation and discrimination against employees who filed workers' compensation claims. So if an employee has filed a claim, the employer may not retaliate against that person and fire them or demote them, force them out of the job just because they filed a work comp claim. That being said, a work comp claim or injury does not provide a bulletproof vest to an employee from performance issues or other reasons for layoff. For example, if the employer was going to be laying off that employee or department or group of employees anyway, that's acceptable to do as long as there is a business-related reason unrelated to the work comp claim. And similarly, if the employee after the work comp claim has performance issues, and whether it be progressive discipline or other reasons leading to termination or discipline unrelated to the work injury, that is appropriate because they still have to perform up to the standards of their job and the employment situation.
So it can't just be, I had to go see my doctor, so I had to, go to physical therapy and things like that, and then the employer says, well, you weren't at work today, you're out.
Correct.
Can't do that.
And that raises the whole other types of potential employment protections that come into play. The employee may still be protected by the Family Medical Leave Act if the employer is large enough. The Americans with Disabilities Act may come into play in terms of non-discrimination or accommodation issues. There's a lot of different moving pieces once the employment relationship is looked at.
Right. And then if it's a union company, then there might be union protections as well. But the real answer to the question is yes, the employer can fire the person, but the employer then faces consequences. Because that's what,
Right.
That's a good.
because they do it. They do it. Not all of them. In fact, it's
Right.
not very common.
I was just going to say, I think
But-
that's a very rare case that
I
happens.
agree.
So.
Right.
It is rare, but it does happen, and that's when, again, you meet with a lawyer, consult with a lawyer, and the lawyer can determine whether or not an action under the provisions that Kathy just described is appropriate.
Right. A lot of time there's some other facts already at play at the
Sure.
time the work comp claim was filed that perhaps the
Right.
employee was going to be fired anyway, or other circumstances behind the scenes were
Right.
coming into play. So it's usually a lot more complicated than that.
Right.
Okay.
Right.
So Steph, how about this one for you? So thinking about talking to a lawyer about a work comp claim, but I'm broke. How do I pay for a lawyer?
Well,
I do?
First I'll say, in our office, we talk to people for free, at least once. And I think you'll find a lot of lawyers do that. But in workers' comp, the way I put it to clients is you don't ever write a check to me because we're pursuing certain types of benefits. If we're pursuing wage loss benefits or permanency benefits, and permanency is that percentage of impairment that a doctor has to find you having loss as a result of the injury. If we're trying to recover those benefits on an injured worker's behalf, we get paid out of the benefits that we recover for the employee. If we're pursuing medical benefits, for example, if an employee comes in with an unpaid bill, these people are bugging me, I told them it's work comp and they're not paying for it. Great, give me the bill. I'll go get it paid. And then the insurance company, if it's found that the bill was in fact compensable, not only has to pay for the bill, but also has to pay for what's called a RORAF fee. And again, as Sean mentioned, that's the name of a case that held that employees, attorneys can get paid kind of above and beyond the actual benefit. And then if you're trying to recover rehabilitation benefits, which are not physical therapy benefits, but if you need help looking for work, if you need to go back to school, that's a retraining plan. I think that's pretty rare, frankly. But if you need my help in getting those services obtained, then again, the insurer pays for that fee on top of that. That's called a Heaton fee. And so it should be painless for people to come in and talk to a lawyer. Yeah.
And the other thing is the fees are the same no matter who you hire.
Yes.
Because they're governed by law. They're very regulated. And also, before a lawyer ever gets paid, as Stephanie described, we'll get paid a percentage of the benefits that we might help recover. Before Kathy's client will even write us a check, they have to have a judge approve our fee. So it's very, very regulated, very regimented.
Okay. So this person transports people for their job, got in a motor vehicle collision while they were at work. Who pays who for what when it comes to that?
In terms of the driver? I'm assuming we're talking about the driver of the vehicle?
Yeah, so
Yeah.
employees driving the
what he does
employer's
for a
van.
living.
Okay, yeah.
The employee does that for a living.
Going to make a delivery or something. Is that just a normal?
Well, you still have a work comp claim.
Right.
And then you might have, on top of that, a motor vehicle claim. And workers' comp in Minnesota is primary, meaning the work comp insurer pays the medical bills, the work comp insurer pays the wage loss, those kind of things. But if the workers' compensation insurer is denying it, then you will have no fault rights. We probably have a whole nother show during the season for no fault, don't we? Yeah.
Yes.
So, but those are, again, your own insurance company pays your medical and pays wage loss, not nearly as high of a rate typically as the work comp rate. Sometimes the no-fault insurer pays before the work comp insurer decides to accept primary liability, and then the work comp insurer will take over. And then, of course, if you got hurt because somebody ran a red light or something like that, and you want to sue the person that ran the red light for pain and suffering damages for the motor vehicle claim, you can do that. And if the work comp carrier paid your medical, paid your wage loss, paid some other benefits, then they can jump in and say, hey, if you get a slice of that pie, we get a little sliver of it too. And that becomes very complicated, but that's basically what happens.
Okay, so Kathy, this might be a good one for you. Getting some questions about insurance company doctors. So do I have to go see that doctor, and why are sometimes their reports so different than my own doctor?
I'm assuming they're referring to what's called an independent medical examination, and it is a right of the employer and insurer to have the employee examined at reasonable times during the claim. So it's not just once, but they may be examined more than once. If it's something that the employee feels that has been too frequent, they need to talk to someone else about that, because otherwise an employer and insurer will say, under the statute, we have a right to be seen once. The opinions vary because it can vary based on perhaps the issues being examined. Maybe the employee's been going to a chiropractor and the employer and insurer had an orthopedic surgeon examine them, and they are viewing the employee during very different viewpoints. And so it's just a matter of perspective, and also a matter of potentially the records that each doctor has available to them. The employer and insurer's doctor typically is provided whatever records have been collected on the employee with a medical history, and provided other investigation documents from maybe a deposition summary and things of that nature that provides a full profile that sometimes the treating doctor doesn't have the benefit of.
This question comes from Hermantown. What prevents the insurance company, I'm guessing the employer, from pushing you back to work too soon? You know, you get hurt, you get some treatment, you don't feel like you're quite ready to go back. Does anything prevent that from happening, or?
Well, it sounds like the phrase "going back too soon" is what we're talking about here, and deciding what is and is not too soon has a lot of factors, and there's a lot of people involved in a workers' comp claim at this point. Hopefully, if the injured worker has recovered to some extent and is returning to work from being off work, I would hope there's what's called a QRC involved at that point. And in Minnesota, you're entitled to assignment of a QRC, a qualified rehabilitation consultant, to help navigate some parts of a workers' comp claim, in particular facilitating the return to work, especially if it's with the date of injury employer. And you're not always entitled. You have to go through a consult and an evaluation to determine that. But I really rely on the QRC at that point in time to go in between the injured worker and the injured worker's doctor and the employer's representative and the adjuster, because again, the goal for everybody here is to get the injured worker back to work, making as much money as he or she was making at the time of the injury. So it's in everybody's best interest to facilitate that. But what does happen, as the caller has referenced, is people don't want to be paying the injured worker while they're out on work, or there could be doubts about the validity of the injured worker's pain complaints. There's all sorts of things that can happen at this point. And what you want to do at first is to work with your QRC to make that happen. That's really, again, the neutral person who can be going in between everybody and trying to facilitate this. If really an injured worker doesn't think he or she is ready to go back to work, then that's a conversation to have with the doctor, the treating doctor who is in charge of the restrictions, whatever they may be, on the injured worker. What can happen is the independent medical evaluation, which Kathy referenced, sometimes the insurance company's doctor says you're good to go. You don't have any restrictions, or if you do, they're not related to your work injury. And then we have two doctors with two different opinions. And in a lot of workers' comp cases, you should never need a lawyer, but it may be time for a lawyer at that point in time.
Now, speaking of QRCs, I know you can change QRCs under certain conditions. What would that look like? I'm unhappy with my QRC. I don't think they're listening to me. I'm not ready to go back to work. What can I do?
Well, normally, I mean, the law says that the employee gets to choose the QRC, but that is very rare because how many of us know who a QRC even is? So the insurance company says, hey, we found a QRC for you. And generally, if within those first 60 days, if the employee is unhappy with that person, they can make that switch and there's really not going to be much of a fight about it. After that, then there might be litigation over, I want to switch to a different QRC, and the insurance companies, no, we're happy with this QRC and we think that person is providing good services. Normally you try to work that out, and frankly, if the employee is unhappy with the QRC, most QRCs don't want to be the QRC anyway, so the switch usually happens. But there can be fights over that. But if it's within the first 60 days, it's usually not a problem.
So this question comes from here in Duluth. This person is 55 years old. Says they're drawing a pension. Can they also draw unemployment at the same time? I'm not sure if that's, without knowing more facts, that might be,
Right, and
be
again,
a tough one
you
to
have to be
say.
willing and able to work to qualify for unemployment, and you also have to have worked recently enough. It's kind of like the Social Security system, having paid in credits. So yeah, that's hard without knowing more.
Yeah, and it's not really a workers' comp claim, but it's a work-related claim. But it depends on, why are they not working is really the question. If they're not working because they got laid off.
Was it a disability pension or a retirement pension
Sure.
too?
Right.
So I think the nature of the pension may determine whether or not they'd be qualified for unemployment and the circumstances, as Stephanie mentioned, of why they aren't working.
How about this one? This is an interesting fact pattern, and any of you can chime in on this. My boss asked me to represent the business at a local charity function. I was volunteering my time, and I wasn't getting paid. Ended up burning my arms and hands pretty badly. Can I make a work comp claim for that?
I would say yes.
I would say maybe.
I would say maybe.
I would make it. You might lose it.
Yeah.
And I would deny it, and,
Yeah.
and I might lose it,
Yeah.
but I think
Yeah.
it depends on, was it voluntary or was it required?
Yeah.
And that's really a lot of the guts of the question in terms of whether is it a volunteer event on their own time?
Yeah, but if your boss asks you, what
Well-
are you going to say? Nah, I'm good.
And
Thanks.
Well,
you're
you know-
representing the company's interests at a different function. If you volunteer
Yeah.
at your own office, hey, it's the office Christmas party, I'll make the hors d'oeuvres or whatever, and you burn yourself doing that.
At home?
At home.
Okay,
or,
that
or,
wouldn't
or
count.
even in the kitchen at the company and you punched out or whatever. You're not going to be covered. That's a voluntary activity. There's no coverage. This situation, you're volunteering somewhere else and you're wearing the company t-shirt or whatever.
We don't know that, though.
Well, we don't know, right? But they're representing the question was, I'm representing my employer at this function.
marketing.
We need Judge Arnold or Judge Baumgarth here to answer the question. And
Well, and I think sometimes people say, my employer asked me to do something, but it came out as, we have this opportunity that if anyone from the company would like to go to this, you are welcome to, and we'll support you in doing this, but it wasn't required. It was purely voluntary.
It's
And in
voluntary.
that case, it probably wouldn't be
Yes,
compensable.
I would agree with that.
So,
But I was at the company softball picnic and I broke my ankle sliding in the home, not covered, that kind of thing.
Right.
So.
Okay, Sean, how about this one for you? If I hurt my knee going down the steps at work, work comp will pay for my medical bills and wage loss, won't it? Or does it depend?
All right, well, here, first of all, it depends on, had you asked me this question a year ago, because if you had asked me this question a year ago, I would have said, no brainer, yes. Now, I don't know the answer to that question. The Supreme Court issued a decision recently that I don't really think changed the law very much, if at all.
I'd
But-
agree with that. Yeah.
But it certainly changed the perception of what the law covers, if to no one else, to the insurance companies. Woman was walking across a flat surface and for no apparent reason fell, and she hurt herself. Normally that person's not going to win. But for no reason whatsoever, just because they were maybe interested in making sure we remained busy with litigation, they added a little footnote that said, it's just like walking up and down the stairs. If you fall on the stairs, that's not necessarily covered. And that caused turmoil.
Well, but it was relevant because the whole issue was whether the injury or accident occurred under a situation which presented an increased risk of employment.
Right.
And that's the whole crux of whether the work activities or work environment actually contributed to the risk of an injury. And so the little footnote on the steps was actually just another common situation that arises at work, but really is a situation that often doesn't present increased risk.
I'm Bob Falsani all of a sudden now. Stairs
That's very frightening, yes.
Stairs are dangerous, no matter what, always. They're just dangerous because they're not flat. They're
Yeah.
up and down.
He claims to have some
Inherently
objective
dangerous.
They're
data
inherently
saying
dangerous.
stairs are inherently dangerous because they are stairs.
Just the mere fact
Because
that
of the
they're
changes
stairs.
in elevation, he's
Yeah.
got something
And so,
from an expert on that. I'm not sure.
And I think he's right, but I'm not Judge Arnold, I'm not Judge Baumgarth, I'm not a Supreme Court justice, so I don't know what the right answer is. So, what that means presently is that there are going to be a lot more denials by insurance companies on claims that they never would have even thought in a million years of denying a year ago.
No,
And-
I don't know. I would go that far because I think it didn't change the law dramatically. And the issue is still whether there's an increased risk of employment and
Increased risk of injury.
exactly, in injury while employed,
Right.
and the circumstances of each injury is taken individually. Because
Right.
going across the floor, going down the stairs, the answer is it depends, as Stephanie
Right.
said before.
And Sean and I agree with you, but I don't think all of the insurance companies do. I think what's happening is they're interpreting it differently, and I think because it works sometimes, if you deny an injured worker a claim, sometimes they don't pursue it. I mean, I think it works out. And so I think you're right, but the actual what's happening is different from what the law is.
Right.
So that's my perception.
So it means we're all going to be very busy, is really what it means.
Good answers. So this question comes from International Falls. Can an employer idle you, or I'm guessing this means
Layoff?
lay off, or not necessarily fire, but say you got hurt, you can't come in the doors for, we don't want you as a risk around here for X amount of time. Can they do something like that?
Yeah.
Well, I think the question is, are there restrictions? Is the employee under restrictions? What are the circumstances of this idling? Is it economic idling? Is it due to restrictions?
So
Economic idling, no question.
Right.
There's another mine just was announced to being shut down. No doubt there's at least several dozen employees at that mine who have work injuries. Well, they're all going to get laid off.
Right.
So they can do that. If an employee got hurt on the job, the employer, going back to that question we discussed 10, 15 minutes ago, employer can't just say, you can't work here. But if he has restrictions, then maybe they can.
Well, the employer can.
Well, right, going back, yeah, right.
But it depends. An employer can say, I don't want you to work here for all sorts of reasons and be protected under the law, okay? What we're really talking about is if an employer does that under the Minnesota Workers' Comp Act, is there recourse? Is there something I can do about it? Right?
Right.
I mean,
Is it different even if they're not, fired per se, but say they get hurt and then the employer views them, during their recovery time and their treatment time as, a greater risk for further hurting themselves on the job? Can they say, well, we're just not going to schedule you for 2 months, even though the doctor says you can work, you're able and willing to work?
That's a different fact pattern. And under there, that really implicates almost more the Americans with Disabilities Act, and the perception of being disabled, and employers have to tread carefully that they have an objective reason to not employ an employee or put them into a certain position rather than just a fear of re-injury or a perception of disability, because that may create some concerns with disability discrimination.
And then there's the question of whether or not they could reasonably accommodate the whatever injury or perceived injury there might be. And if there's a reasonable accommodation that can be offered, then they should offer it. If it's, well, we have to, completely redo the factory, then that's different. But,
And
give
it-
you a chair.
And it depends if they qualify as an
Right,
an
not all
employee under
employees.
the Americans with Disabilities Act. Not everyone who has a work comp claim or work comp injury is eligible for coverage under that.
Right, and not
the
all
act.
employers are covered by that act
Correct.
either. So.
But generally, if an injured worker has restrictions to any degree, by a doctor ideally, and an employer doesn't make work for that worker, whether it's, I'm idling you, or I'm firing you, or whatever, then work comp is supposed to be paying wage loss benefits during that time period,
Right.
as long as they're under a restriction relative to the work injury and there's no work.
There are some employers who have, it's a company-wide policy. If you have restrictions, you don't work.
Right.
Period. You can only work if you have unrestricted, abilities. Well, if they enforce that consistently, then there's nothing we can do about it. But then, as Stephanie said, you get work comp benefits.
Okay. So, Kathy, this might be a good one for you too. This question comes from Hibbing. Say the insurance company admits the claim and starts paying benefits, and then they try to cut this person off. So, I guess under what sort of circumstances would an employer insurer say, we admit the claim, we've been paying on it for a while, now we don't want to anymore? Can you tell us about that?
There's quite a few circumstances that benefits can be discontinued, and I'm going to assume that they've still admitted liability for the claim, because it's really two different issues if they've reversed a liability finding and have decided they don't admit liability for a claim at all, versus discontinuing benefits with the injury they admitted to begin with and they still admit. But they're claiming perhaps that the employee is supposed to be looking for work and they're not doing a diligent job search. So they cut off their benefits because they're supposed to be doing that. Perhaps the employer made a job offer that the employer and insurer consider reasonable and within restrictions, and the employee says either I'm not comfortable with it, or I don't think I can do it, or doesn't show up for the job. That could be another basis to discontinue. Perhaps they haven't cooperated with the QRC, that qualified rehabilitation consultant. They haven't returned the calls, they haven't timely met with them. There are many reasons someone could be discontinued with their benefit stream.
And importantly, they can only cut off, in those circumstances that Kathy just talked about, they're cutting off the wage loss benefits. Doesn't mean the medical benefits end, or any other benefits. And there are circumstances when the employee can then be a good boy again and get back on the benefits, but not always.
And medical may be discontinued. There are circumstances
Right.
if they haven't, let's say they're supposed to be going to physical therapy twice a week and they don't show up. Benefits on the medical side may be cut off too, saying you're not complying with the recommended medical treatment plan. Or perhaps they're found there's a positive drug finding or something of illegal drugs complicating the medical treatment or recovery. Things like that can also interfere.
And the other important thing is when the insurer wants to do this, we're going to discontinue your wage loss benefits, for example. They have to send a notice to the employee saying, we're going to do this. And the employee has a right then to file a request to have a hearing right away. Now, you only have a short amount of time, usually about 12 days. Is that right, 12 days? Yeah, 12 days to request a hearing. And if you do that, you'll get a quick hearing and a quick answer. And it's not a final answer, but at least it's a temporary answer that, yes, they can still cut you off, or no, they can't. And then it can go to a full-blown hearing later on.
Okay, so another question from International Falls. I know Stephanie and Sean, you both do quite a bit of Social Security work. Can you collect work comp and Social Security at the same time?
Steph, go ahead.
It depends.
You get
Well,
That's the answer
okay.
to every question.
I know.
So that's
Okay, so to be on Social Security, you have to have been disabled and unable to work what's called substantial gainful employment for at least 12 months. Now, In order to be on Social Security, you can't be making so much money. So you can work a little bit, but not a lot. You can also get, if you've been rendered unable to work from workers' comp, as Sean had mentioned early on, there's a couple different types of wage loss benefits. One is temporary total, which is when you're off work completely. Another is permanent total, when you're off work completely for a long time, okay? And to get perm total under workers' comp, you can't work at all. You can't even be working a little bit. Well.
A little bit.
Okay, yeah, a tiny bit. It depends. So Social Security and workers' comp, you can get both benefits together for a period of time, but then what's called an offset kicks in. And I'll let Sean take the offset.
Oh my God.
Give us a brief overview of offsets,
All right.
because that's a common term.
Here's,
This show is only an hour.
I
Yes.
understand. Short version. If you're getting temporary total benefits, you get those temporary total benefits, and if you're also receiving Social Security, the Social Security Administration will reduce how much they pay you, not necessarily dollar for dollar. They have a separate formula. If you're getting permanent total benefits, then the same thing that I just said applies until you've received $25,000 in permanent total benefits. Then the offset switches, and you get all of your Social Security, and then you start losing workers' comp dollar for dollar. Everyone got that?
Well,
I
yeah.
mean, it's
And
really
also,
complicated.
if you have dependents who are receiving Social Security
Oh,
benefits,
yes.
not only are your benefits offset from permanent total disability benefits, but also your dependents. And so the offset may be complete from your workers' compensation benefits stream, and that's, the employer and insurer have a right to do that by statute.
Right. And there's offsets if you're receiving PERA or MSRS. So there's a bunch of reductions of work comp permanent total benefits, not temporary total benefits.
And what I would say to anybody who's dealing with this situation, let your Social Security office and your workers' comp claims adjuster know about each, because what you really don't want to deal with is a claimed overpayment.
Overpayments.
Yeah.
Oh.
The dreaded
So
overpayment.
when in doubt, just give all the information to everybody, or call a lawyer and ask them to figure it out.
Right.
So it's not a situation you want to mess with.
Well, this is a interesting question. This is out of Hibbing. You got hit in the head with a backhoe at work, but the driver of the backhoe is not licensed to operate it. What sort of recourse might I have there?
Well, it's a straight workers' comp claim. I mean, whether the person who caused the injury was licensed or not doesn't affect
Right.
your eligibility for benefits, but it sounds kind of like an OSHA claim too, maybe.
Well, there's also, theoretically, this could be a situation like what Kathy described earlier in the program, where the employer does something really egregious, letting an unlicensed person operate a heavy piece of heavy equipment. Might be, probably not, but might
Lori,
be.
I was
But-
going to say, I think it's a straight work comp
I do too.
claim.
But then there's also the question of whether the unlicensed backhoe operator was working for the same employer that you were working on for.
Nice catch.
And if they were working for different employers, then that injured person might be able to sue not necessarily the backhoe operator himself or herself, but the backhoe operator's employer, but maybe not, because
Oh,
it depends.
It depends. Yeah.
'Cause it's very complicated, but if they're operated in what's called a common enterprise, where they're both working for different employers in conjunction for the same purpose, then you probably can't. But if they just happen to both be on the same site, then maybe you can.
Yeah, anytime there's multiple employers working on the same site, a work comp claim can get complicated, especially if the employees from different employers or different entities are overlapping their work areas and, excuse me, and work tasks.
So we hear the term statute of limitations quite often. This is a question out of Chisholm and a date of injury question. So say it's an admitted work comp claim. Is there any sort of statute of limitations on claims into the future? Or what happens when a claim is admitted? Is there any time limit on, I'm guessing they're asking when the employer stops paying or additional claims?
And the basic answer in terms of filing a claim is I'm not sure if they are asking which, but is three years from the filing of the first report of injury, or 6 years if the first report of injury was not filed?
That's if the claim's never admitted. the claim's admitted, once the work comp insurer pays 1 penny of anything, wage loss benefits, medical benefits, vocational rehabilitation benefits, that's it. No more statute of limitations forever.
Right, statutes of limitations, but then there's all these different deadlines for different types of benefits.
Right,
So, and the one I'm thinking of is retraining.
right. Yeah, so,
Right.
right. And you have to make a retraining claim before you receive so many weeks of certain types of wage loss benefits. And if you don't make that retraining claim ahead of time, you can never make it. So there are those statutes of limitations.
And there's also the limitations provided by statute for how long certain benefits may be paid. And I don't think we've touched on that in terms of
No,
the
go
fact
ahead.
that the statute limits certain benefits based on your date of injury. So certain benefits have different benefit tiers, say 156 weeks of temporary total disability benefits. You could continue to be disabled after that, but the statute says you're done as an employee who's injured. And so the statute may also affect how long you can receive a benefit and whether you can ask for more.
I guess just a follow-up question on that. So say that those number of weeks are paid, but the person's still disabled. What do they do then? Does it become a permanent total issue, or
That's
when
really
their time
hard.
runs out?
And I have a
It
case that
depends.
fits exactly within that frame because, and it's a sore point for petitioners' lawyers because those deadlines put someone that you just described in a really awful spot. You've run through temp total, but you're not permanently totally disabled yet. You know, if someone doesn't get the medical care that they need for whatever reason, or they get bad medical care and it went wrong, or, you know, there's all sorts of things that can make it impossible for someone to heal and get back to work within, you know, so many months. And there isn't a solution for that. I can tell you that I have my tactics as far as getting out ahead of that, because you can see it coming from a ways away if you're paying attention. And if the injured worker has a QRC, you're hopefully working with them to try to get some feel for, you know, what's happening down the road, what's the doctor going to say at the next visit. And sometimes you want to file a claim for permanent total before you know for sure, because frankly, it can take a really long time for a claim for perm total to actually go to hearing. That's a lot of work. That's a big claim. And so the short answer is tough toenails. I mean, there isn't any way to fix that. But the longer answer is
legal term?
yes, it is.
Okay.
But I think
For us young folks.
Yeah.
it's a great illustration too of why getting back to work is really important too, because there is limited benefits involved, and it is mutually beneficial to the employer and the employee to get back to work as soon as possible, even if it's at a partially disabled state or within restrictions.
And the last thing I'll add is this. The big wage loss benefit is the permanent total benefit. I'm permanently, totally disabled. And sometimes you're permanently, totally disabled, and then you're not, which means the definition of permanent is slightly different than the normal everyday definition. Every once in a while, it doesn't happen too often, but every once in a while, someone is in fact permanently disabled and then gets better, goes back to work, and then they're not.
I think it's a rare case though.
It is rare, but it does happen. And so sometimes when that stream of wage loss benefits, temporary total benefits, is getting near the end, it's almost 3 years and they're still out of work, you can go ahead and file a permanent total claim. And if it's a really sympathetic situation, a judge might go ahead and grant it, even though 2-3 more years down the line, you're going to be
Because the
back.
insurer has the right to cut someone off from perm total. I mean,
Right.
it's not as if once you get on perm total benefits, the insurance company just sits back and sends checks every week. That's not it at all. They still have this ongoing right to know about you and what you're up to. And, you know, in some cases, there's surveillance, you know, to keep an eye on you because they question what you're up to. But so it's not a system that you can just, you know, make your case and then you're done. You know, you don't have to worry about it in this situation, the situation Sean's describing.
Question out of Duluth here. I've heard this before. Would an independent contractor or a freelance worker, so a non-employee, somehow manage to qualify for work comp?
They pay for their own policy is the only way I can think of it.
They're not going to be an employee of the employer under their work comp policy, so.
Yeah, independent contractors can buy their own policy and cover themselves. The real question, though,
yeah.
is are they an independent contractor? There are a lot of employment situations that we see time and time again where the employer is telling their employees, and they really are employees, well, you're independent contractors. And they're not. They're really employees. So the real question is, are they independent contractors? In my experience, I would say 9 times out of 10, they're actually employees.
There's an analysis that we apply in that situation as far as the degree of control that the employer has over this person. So, you know, if an independent contractor is showing up with his or her own tools and they're making, you know, they are responsible for their work on the project and there was just this initial contract, you know, that sounds pretty independent. But what Sean's describing is more likely a situation where, you know, you have the overseer of the job, you know, treating these independent contractors, you know, be here at this time, this is how I want you to do this job, use these tools, you know, this, that, and the other thing. So it depends.
Another question in Duluth. So this is an injured federal postal worker, you know, having some difficulty, you know, finding somebody to take his case. You know, this person asks, you know, is the federal system harder to work through, and
Yes.
why, and any advice for this person?
Yeah, and it is, first of all, with federal postal worker, you're dealing with a different system than what we've been talking about this evening with the Minnesota State Workers' Compensation.
That's right. Everything we've said today applies to Minnesota State, not Wisconsin, not federal. There are only a handful of lawyers that I even know that do federal workers' comp litigation. And so if that person wants to call me tomorrow, I'll give them a couple of names. It's a more complicated system, and it drives the lawyers kind of crazy too, which is I think why so few of us do it. None of us, I don't know a single lawyer in Duluth that
I don't
does
think
it.
there's anybody in Duluth, and I think the lawyers who do take them do frequently ask for a retainer because of the nature of the work involved and the odds of recovery.
Interesting question. So, person out of Hermantown, injured worker, employer or a manager yelled at her in front of other employees, saying that this person's costing them X amount of dollars per day for being injured, just for the sake of being injured. Is there any specific recourse that person has, or what sort of advice would you give somebody who's being humiliated in front of their fellow employees for filing a workers' comp claim?
Well, Kathy talked earlier about this statute that prohibits employers from terminating employees, and the statute provides for a lot of things. Terminating employees, mistreating isn't the word. I'm trying to think of all of the...
It has to be very adverse to count as retaliatory
Right.
conduct.
Yeah, so...
Yelling at probably doesn't count, unfortunately.
Yeah, it's probably not
Right.
going to get there, but...
If it ends up
it's
being
really,
a factor...
I mean, it's really inappropriate, obviously.
Yeah,
for the
I
employer
don't
to
think
do
there's
that,
any
but I don't know if there's
recourse,
necessarily
yeah.
legal recourse there.
Because
But-
it doesn't sound like discrimination or retaliation because this hasn't affected the terms and conditions of the employment in terms of the status or
But
discipline or anything like
But if
that.
that employee is particularly sensitive, and you know, geez, now I'm really embarrassed, and then they end up not being able to go to work, then they might have not only work comp claims, but you know, theoretically claims under this other statute too. Again, it depends. If you have a really sensitive employee, that would be very upsetting to that person. I could see how it could turn into something.
Well,
you know.
and frankly, if that employer down the road says, I can't find any work for you, or whatever, I would certainly bring up that conversation because that certainly sounds like that's a factor in the decision. That's retaliatory.
Okay, well, we've only got a couple minutes left here. So as far as wrapping things up, and I'll open it up to all of you, what's the biggest mistake that you see injured workers make? Is it the time that it takes between reporting it to the employer? So anything like that you would give an injured worker some advice to make sure that they don't make that mistake in their claim?
I'll go first. Again, I'll go back to what I said at the beginning of the show. The number one most important thing is to report the injury. And I see that time again. Later this month, Kathy and I are trying a case over notice. That's the only real issue in the whole case. You got to tell your boss, I got hurt on the job. It's really important.
And I would say the thing from the employer insurer's perspective, tell the truth. Tell all the facts, and don't try and hide anything, because typically the real facts come out. So be honest from the get-go and tell everything timely.
I would say I see a lot of injured workers who don't pursue anything because they're scared. Or because they don't want to make someone upset. And it never hurts to ask. And so if you're wondering whether you're entitled to a benefit or if you should fight something, just ask. There's no harm.
Great. I think we've got about a minute left here. Any final words?
Thanks for coming,
I was
Kathy.
just going to say thanks for having us. And,
Yeah, you kind of
and hopefully it's been
dove
informative.
into that, yeah. Well, very, very interesting to hear from all of you. And well, that's all the time we have tonight. I want to thank our panelists, Sean, Kathy, and Stephanie, for doing a great job with our questions tonight. Remember, you can watch the show again online at www.wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Beyer website. Please join us again next week when we answer your questions about family law. I'm Paula Polasky. Good night.